All right, Miss Sandy, are you ready? Great. Let's get on the record. This is 2020. That was me. CV343938. Favorito et al. Versus TPD. We'll see who's on the other side of the V. We need to work through that today. It will help me because this is my first time working with some of you to figure out who we've got for whom in this case. So my understanding is that Mr. Favorito, Mr. Terrace, and Mr. Peck all have the same lawyer, but why don't you clear that up for me?
Yes, sir, that's correct.
You're Mr. Harding?
Yes, sir.
All right, Mr. Harding, nice to meet you.
You too.
And your three clients are still in the case. There's not been any severance, or we're going to talk about someone may have been severed when this was a Judge Amaro production, but that's not your client, none of your clients. All right. And then we have Ms. Jeffords.
Yes, Your Honor. Good afternoon. Harry McDougall for Ms. Jeffords.
All right.
And I believe her claim was severed. And there, we haven't yet had an opportunity to discuss that, but the causes for severance may have dissipated, and it might be possible to bring them back together. But I'm unfortunately not in a position to say, answer that question.
What is your understanding as to why her case or her claims were severed from the other three petitioners?
Sure. I am a little bit new to the case, Your Honor, but and Mr. Harding may be able to answer this better than me, but my understanding is there was a disagreement about strategy and experts.
And Judge Amaro severed the case because of that?
I need a little help from Mr. Harding.
Clue us in, Mr. Harding. That seems like I'm not critiquing a colleague. I'm sure it was the right decision at the time. I've just never heard of that so much as maybe you just have the attorneys sit far apart.
Well, and we did that too, Your Honor, but that's about it. There was a separation and within at the time there were 9 petitioners, and then 2 of them had their own counsel, and I ended up with the other 7, but that's primarily what it was, just a disagreement on strategy. Was Ms. Jeffords one of the 2 who, what happened to the other?
That was Purdue, right?
No, that was Sotier.
Yeah.
Okay.
I believe she's a non-resident, so I think
she's not in the case anymore.
Correct.
Yes, sir.
Got it. What is your view, Mr. Harding? It's not a formal decision yet, but what is your view on rejoining the parties so that we have single proceedings for all the petitioners?
Well, I would agree with my colleague. I think that the underlying issues have probably dissipated since the severance order has been issued.
Okay.
So I need to huddle with my client, but I think we'll report back to the court on that.
Good. I'll just add that on a to-do that and that may be email communication between Ms. Niles, myself, and then all the lawyers for the parties so that everyone's hearing the same thing about how we would mechanically rejoin or unsever Ms. Jeffords only after you've had a chance to think about it and confer.
In my recollection, it's been years. It was really only severed for trial purposes, I believe.
Okay.
I'd have to go back and reread that order.
It's a pretty big record, and I am a little new to the case.
Okay. All right. I don't know who our respondents are. I know that we are going to be working through claims for attorney's fees that are being brought writ large by the county attorney, but on behalf of the clerk of court and then on behalf of the county. Who is here for that?
Good afternoon, Your Honor. Kay Burwell. I'm here on behalf of Fulton County for purposes of the fee motion. And the witness that I will use, Your Honor, is David Lohman. And I would note that because we had affidavits also from Cheryl Rayner and Stephen Rosenberg, they're no longer with our office. So we're going to withdraw the claim for their fees. And only, so we have Mr. Lohman here today to testify as to his fees.
Okay. And Ms. Burwell, you are here for both the clerk's efforts to recoup attorney's fees and the counties, or just the counties?
Just the county.
Okay. And now it's just Mr. Lohman's fees because Mr. Rosenberg and the other name you mentioned are folks who aren't with the office anymore.
Exactly.
Okay. So who is here to argue for the clerk's fees?
Good afternoon, Your Honor.
Hi.
Hi, my name is Laura Moore, and I'm here on behalf of the clerk to argue for her fees. And Madam Clerk is here, Shay Alexander. And our witnesses are going to be Ms. Guggen Fider Swan.
Okay.
I hope I didn't butcher her name, but she's on the Zoom with us. Thank
Yep.
you. And Ms. Dominique Martinez as well.
Okay.
And Kay Burwell also did an affidavit for fees on behalf of the clerk, and we will just stand on her affidavit since she's here today on behalf of the county, if that's okay.
Okay. And so I'm
Okay,
less confused. You and Ms. Burwell are colleagues.
correct.
Any reason why it's just not one of you handling? I appreciate it's two different entities, and maybe that's it just keeps it clean that way. You, Ms. Moore, will be articulating the reasons to award the clerk's office attorney's fees, and just so that there's a clear division, or that's your client, and that's why I'm just trying to figure out why it's not one lawyer from the county attorney's office.
Yes, correct. It's just to keep things separated. That's the way it's been handled in this case since the beginning, as I understand it, although I too came on well into this. But the clerk has always had separate counsel from the county and from the BRE.
Got it. Okay. Separate counsel from within the same firm.
Correct.
Okay.
Good afternoon, Your Honor. To make it a little more confusing, I'm Richard Kaplan, also from the Office of the Fulton County Attorney.
I was waiting for your name.
And
Okay.
I am here to argue the motion to substitute parties.
Got it. Thank you, Mr. Kaplan. So you represent any respondents. It could be you represent Alex Wan, who is not in that role anymore. But for now, you represent Mr. Wan, Ms. Nuruddin, Ms. Ruth, Aaron Johnson, and Mark Wingate.
I am here on behalf of the respondents. Yes.
Okay.
And sorry to interrupt, but I take it he also represents the proposed incoming parties?
TBD. We'll see.
Okay.
So are there any county attorneys left? Are they all in this court? Now is the time to steal something from the county. All the lawyers are here. Yeesh. All right. Ms. Joe is not here. All right. I appreciate you helping me get my sea legs. I have looked through the docket, which is how we framed what issues we're going to cover today, but it's just the petitioners being severed and who the respondents are that remain a little mysterious to me. Okay. I think what we're covering today, and if there's more we can fit in and the two sides have agreed to talk about it, we're going to discuss the petitioner's motion to substitute parties. And I guess I'll need to make sure, is that only Mr. Harding's clients or also Mr. McDougall's client to substitute parties? Two attorney's fees motions. We just talked about that a little bit. Ms. Burwell on behalf of the county, Ms. Moore on behalf of the clerk's office. And then I asked that we also be ready to talk about preserving the electoral results evidence. I think I'm the one who entered the order way back when. I don't know if it was through this case, but I know at one point in time, I signed an order directing, it was then Clerk Robinson, do not destroy the electoral results evidence. And don't know that anyone has ever said that order has expired, but we want to talk about that because it may mean nothing needs to happen, because the representation may be, don't worry, that evidence is going to remain under lock and key for the next 100 years. But I certainly want to touch on that while we're together today, because if not, there'll be a lot of explaining to do, and much of the case might be moot if that evidence is now gone. So those are the four things. Mr. Harding, was there anything else you were thinking we'd work through today?
No, sir, those were the items we believe. And just for housekeeping, Mr. McDougall is gonna be making the argument for both of us, just to consolidate it so you don't have to hear
Okay.
duplicative argument.
Okay, I'll probably, just because it's a matter of practice, when he's done, ask you if there's anything you want to add, and you can say what he said, and that'll be all you need to say.
And there may come a time where I have to turn to him if you ask me a question about the history of the case that I can't handle.
Okay, sounds good. Ms. Burwell, you're here on a very well-defined mission, and same with Ms. Moore. Mr. Kaplan, would you be the one who would be weighing in if we do engage in a discussion on the preservation of the evidence? Because you're kind of counsel for one of the parties. I mean, what we got here with Ms. Burwell and Ms. Moore is counsel for no longer parties who want their attorney's fees for the brief time they were parties. And then I think you're the last man standing on that side of the V.
My understanding is that the evidence is being maintained in part, at least, by the clerk, and that's why my colleague, Ms. Moore, is here on behalf of both the fees issue and that additional.
Great. Okay. Way to pass the buck.
Just down the hall in the same office.
Yeah, exactly. I figured you were going to say in courtroom 5A, all the evidence is sitting, but okay, we'll get to that. Is there a particular, will you be able to leave, Ms. Burwell, after you do? I don't care the order in which we do it. If you all have agreed you're going to go in a particular order, but if we have a way to do it where some of folks can then be done and like, I'm out of here, we could do it in that order as well. You're here the whole time.
That's correct, but I think I may have a helpful suggestion to what you just said, which is the preservation of the records. An order to that effect was entered in this case, and it was directed to the respondents at the time and all persons acting in concert with them. And at the hearing on that, that was dated January the 7th, Your Honor.
Of what year?
21. And at that hearing, the clerk and the county did not object to the entry of that order. So if that status quo will be maintained going forward, then we can check that box and let the clerk go.
All right, give me 1 second. And that may not let the clerk go, but
Well, you're right, because they want fees.
they do. Just
They can waive the fee claim if they want to.
I didn't hear Ms. Moore say that, but we'll see. We'll give her a chance.
I have a hard copy of that order if you need it.
I got it now. I had my dates mixed up. It is a big docket. Okay, so there is, Ms. Moore, an order that Judge Amaro entered. It's labeled a temporary injunction, so I could see how that would give someone cause. Temporary doesn't mean permanent. That for a little while, people should preserve all the many things listed in there. Do you believe that that's sufficient to protect everyone's interests, or where are we with that? Are you here to say, we're done, we don't want to preserve the evidence anymore, find your own warehouse?
That's correct. We don't want to, the clerk does not want to continue preserving the evidence. I have some pictures of the current warehouse where the elections records are being stored, if the court is interested in seeing those, but they show that all the documents that are currently there are pretty much filling the entire space, the space that's devoted specifically for elections records, because those have to be secured. So it's under, lock and key, kind of in a caged area that's separate from some of the other clerk's records. And so elections are ongoing and we have elections coming up.
We do, yes.
The clerk would really like to be able to move out old stuff so that she can fulfill her obligation to store the new stuff that's going to be coming in, because if not, it's going to be an expense to her office to expand that storage area and to accommodate all the records that will be coming in. And Madam Clerk is here and can speak to that as well. We would like to take that issue up first, if that's okay, so that she can then go on. She's not really needed here for purposes of the attorney's fees discussion, but we know she's busy, and we would like to address that first. If that's okay.
Yeah, here she's busy. Out with the old, in with the new, sounds like is the theme. So I'm happy to hear from Clerk Alexander if we need to, but let's explore this. You're not saying, Ms. Moore, that you seek destruction of the records. You seek to shift whatever obligation there is to maintain the records away from the clerk to someone else, so this big cage can be opened up for the next wave of records that'll be coming in November.
Well, the statute permits the clerk to, well, she's required to keep them for 24 months, and then I believe they go to a grand jury. I'm not exactly clear for what purpose, but then after that, they can be destroyed legally. So we would presume to follow the processes set forth in the law, and if they get destroyed, they get destroyed. However, if I suppose, if the plaintiffs want to pay for continued storage or provide that, I'm not exactly sure how that would work, though. I mean, that would require lots of further discussion. But from the clerk's perspective, she's fulfilled her statutory obligation to maintain those records, and her obligation is over with at this point.
Well, maybe. What gets the clerk out from underneath Judge Amero's order? Other than you saying, gosh, it's been a long time and we'd like to use the cage for something else.
Well, the case was dismissed, and there hasn't been any new injunction. To your point, it was temporary. It wasn't clear to me when it ended. The petitioners haven't demonstrated any success on the merit, so I don't know on what basis we would be continuing to require the clerk to maintain these records, and until when. I mean, we just need some clarity on that, because it does have a significant impact on operations, and they cannot just be held forever.
Do you know if there are any orders in place from the election interference criminal case with Judge McAfee about preserving this same evidence, so that even if I were to grant you the relief you're seeking, which is making clear that this TRO, or whatever we're going to call it, is no longer in place? It's sort of like the guy who pleads guilty. Great, I've resolved my case, but there's a hold from another jurisdiction. He's not going anywhere. Is there anything that Judge McAfee has put in place that says those records need to stay where they are, or might he be relying on Judge Amero's January 7th, 2021 order? Or I'm not asking you to comment about what you don't know. I just know that
I don't know the answer to your question without doing some further research. As I understand it, the clerk has been continuing to hold on to the records based on this January 7th order in this case. And I can't speak on the other case intelligently, sorry.
No, that's okay. You weren't here for that. I just wasn't sure if, I just figured that the clerk's team would know if there were multiple orders they're trying to strip away so they can.
I think the clerk may know something about that. And she's saying no.
She's
saying no, there's no order.
Okay.
If I may, Your Honor.
Yes, Mr. Harding.
Yes, there are some items that have been subpoenaed in Harrison Floyd's case. He's one of the 19. And this specific order, the January 7th order, Judge McAfee was informed about it. He hasn't issued his own order, but he was aware of it being in place and knows that some of the items overlap.
Okay. So that it's not identical. What, your understanding of what Mr. Floyd is looking for, is it less extensive than this or more extensive, and so he needs records held elsewhere?
It is probably more extensive if I had to guess.
Okay, so who would have the other records he's looking for?
Well, I think some of them the election board has, because there's been subpoenas to the Secretary of State, the clerk, I believe the election board.
Okay. So it would help me, Ms. Moore, if we did maybe you shared a couple photos, just so I have a sense of hey, you know what, this will fit in my garage, I'll hold them and just get this out of everyone's hair, versus, and I'm not actually offering that up, versus, you know what, Mr. McDougal can find, an empty warehouse somewhere and stand guard over them.
Sure. Map of Jura.
Sure, I mean, do you have, whatever you're sharing with me, you've shared with, counsel on the other side?
Yeah, they should have received a copy when I forwarded the documents to Ms. House.
Oh, well, if you, these are these exhibits? Because I've got a way to get to the exhibits. Which ones are they?
They came from me. They were not numbered necessarily when I sent them. So other than.
All right, hold on.
Came from me on Friday.
Would it be clerk's exhibits? I figured it out. Okay, so there are 4 PDFs.
It's the one titled photograph.
Oh, warehouse photos.
Yeah.
That's a good label.
Okay.
What? That's like bigger than a Home Depot.
It's a large, I mean, the warehouse itself is really large. These photographs are just, like I said, of the part of the caged part that is locked for purposes of storing election records. And it's rectangular shaped.
So what we see here is everything in that picture. It should be on your screen right in front of you. Is it not right in front of Mr. Kaplan? So you don't have to look far. Is everything in that picture part of what is being retained pursuant to the order, or that was just a way to impress us with how big the clerk's warehouse is, and we're all very impressed?
Not every single pallet is from the 2020 election.
Okay.
So
if
there are some additional pictures that show.
This is under inclusive. That's not everything right there. It's more than what we see in this picture.
Right. So the big wall that you saw, there are 2 of those. There's another one exactly opposite that wall.
Mm-hmm.
So it's approximately 100 pallets total in the cage. And if you go to the next picture, you can kind of get a sense of how many boxes are on each pallet.
Mm-hmm.
It's about 36 boxes per pallet. So that's just to give you an idea of how many records are there, or boxes of stuff that's there.
Mm-hmm.
Any new stuff would have to go in that walkway that you saw in the first picture, because the shelves are full. But to your point, or to answer your question, not every pallet contains election records from the 2020 general election, but many of them do.
Okay, so the metric will likely be pallets. If we're looking for other space to store things, it would be a question of how many pallets. How many pallets are from the November 3rd, 2020 general election?
Do you know, Lauren, Nisa?
If we don't know today, that's all right. That seems like a knowable thing.
Yeah, I mean, my recollection from being there was that it was about half. Half of the pallets seem to be from the 2020 election.
Okay.
There are 98 pallets.
98 pallets in
2020, 2021, 2022. We don't have enough storage, right? We made it so that we could carry. Do I need to testify?
You don't need to testify so much. It's not, but the 98 pallets are
For 3 years.
for 3 years.
Right. So what we say, because every 2 years they go away, so we have enough room to cover that.
Yep, right. The new comes in as the old goes out. But 98 pallets, that would mean for 2020, it is less than 98.
Right, so I would say a third of that. So
Okay.
probably about a third.
It might be more than a third because it was a general election. 2021 was probably not so much, but let's say it's 40 pallets. Okay, all right. And Ms. Moore, do you know if there are legal restrictions as to how they need to be stored or who could have access to them? They're in the cage, so they're clearly not, this is not like a public library. I could not walk in there as John Q. Public and like, hey, I want to look in box 411, which is on the screen there, and just see what's in there. They're not publicly available records.
correct,
So it would need to be secure storage.
correct.
All right,
Yes, they're supposed to be held by the clerk under seal unless otherwise directed by the Superior Court.
well, that's me.
Yes, that's you.
Okay. All right. So whatever we do, we need to do soon, so they're out of there in time for the next election. All right.
But the May stuff is, we're waiting for it. We won't have room for the May 21st.
That's why soon, right? Where is that? It's being
Elections hasn't compiled it.
gotten it, but then there's gonna be this knock on the door and you're gonna say, no room at the inn, I'll have to go into a manger. Okay. It looks like there's a lot, I don't mean to push back at all, but I'm looking at, there's a lot of, maybe this, like for forklifts to move around, there seems to be a lot of empty space in this giant warehouse.
It's for, this is just a piece of it, it's huge.
Okay,
But it's for the space for the.
but all that hugeness, is that all clerk space, or it's not in the cage, or why is?
So
Okay.
this, when they configured the warehouse, there's the storage for the election stuff is in the cage. So
Got it.
it's secure. So even the staff at the warehouse can't get to it.
Got it. And that's what's much more limited is the cage space. If it didn't need to be caged, you probably have some extra real estate for a little while. Okay. All right. Okay. Mr. McDougall, any suggestions as to what we do here? There's a space constraint with the clerk. I'm going to confer with Judge McAfee. My guess is that there are several judges who will want to keep this maintained until there are closure on issues. We may resolve the issues in this case soon, and then it may be moot, but that may not mean those things can be shredded.
Right. I have a client in the case before Judge McAfee, and I absolutely want these records preserved.
Okay, so if we're gonna send them somewhere else, any suggestions?
Well, not specifically. I have a couple of considerations to offer.
I didn't mean you have a, just fair point.
Yeah,
A warehouse on Fulton Industrial.
And not to be flip, but we can't take them. They're government records.
Right.
The space constraint, I don't know, so I will ask, does the election board have space to take them back during the pendency of this litigation or the pendency of the criminal case?
We'll Judge McAfee and I will work through that. I bet not, but it's worth asking.
They've got a new facility, and I think they're it's been a while since I was on the election board, but are they out of the English Street warehouse now? Completely?
Yeah, it's the same facility that the clerk is in, and as we already mentioned,
And is
there's
English,
only the cage.
has English Street been repurposed to other storage?
Yeah, they're out of there.
It's not ours.
It's out of lease,
Yeah.
so no longer occupied premises, okay.
And what you're saying, Ms. Moore, is that this cage space that the clerk is using, the election board also uses? This is not exclusive clerk cage space?
The cage space is exclusive to the clerk. What I was saying is that the warehouse where the cage is located is not necessarily exclusive to the clerk.
Okay.
There's Board of Registration Elections there, and also the sheriff, I think.
Okay.
So are they doing election day operations or scanning operations there? Okay,
Okay.
sorry, I didn't know that.
I didn't know it either.
I used to know that stuff.
What about Ms. Moore's observation that clerk's done paying for this and using, why should I place a burden on the clerk's office? 24 months have come and gone to figure out where to move these and how to pay for their continued storage. If the clerk statutorily can say, I now no longer have an interest or responsibility for these things.
Well, if the court gives the clerk the responsibility to keep the records, then the clerk has to keep them. But, you know, the idea that these records would be destroyed while this litigation is pending, while State v. Trump et al. Is pending. I mean, the day after they're destroyed, they're going to come in here with a motion to dismiss that the case is moot, and they can't win their case that way.
So, I hear you, and I wasn't suggesting
I
destruction.
know you weren't, but that's what would happen.
Why should it not be a joint expense of the parties to the case to maintain these documents? This is a civil case, so
Right.
burdening the government in a civil case should be the exception, as opposed to a criminal case where the state brings it, and there's a price tag, financial price tag associated with bringing a criminal case. Civil case, your client brought it, and I don't know what the justification would be to extend the financial burden to the clerk, who's not even a party to the case anymore. In fact, is trying to get a refund for money that was expended for attorney representation.
Okay, so, and it's maybe not the right analogy, but in an ordinary piece of civil litigation, one party sends a litigation hold. The burden of holding the records is on the party that gets the letter, and we're in a somewhat analogous posture, but we're in the better posture for our purposes because they're pre-existing without any lawsuit. There's a federal statutory obligation to maintain them for 22 months. That's expired, I grant you, but the case was on appeal for 2 years. In my brief that I submitted this morning, I said almost 2 years. It was actually 2 years and a couple of weeks. That consumed that storage retention period. And the status quo should be preserved while the merits of the case are litigated. And, you know, in light of what our side, I mean, let me offer this. It may be possible for us to confer amongst ourselves and with the county's lawyers to reduce the scope and volume. Now, that would not control Judge McAfee or the parties in that case. And if we hypothesize that those parties or Judge McAfee order full retention, that cost certainly could not be cast upon the criminal defendants, could it?
No, and it wouldn't, and it shouldn't. But then Judge McAfee might engage in a discussion with county officials about how can we relieve the pressure from the clerk's office,
Sure.
who's sort of this unwitting, wait, I'm
Yes.
stuck in the middle of this. I've met my obligation and then some.
So I don't want to be misunderstood as being obstructionist or obstreperous. We will be happy to work with them to come up with a solution that meets their practical needs and meets our need to preserve this evidence for purposes of this case.
Okay.
And so maybe we can't figure that out completely today, but you know, maybe we can confer with our team and narrow the scope of it a little bit and then confer with them and see if that would be acceptable.
So two things. One, a gentle pushback on the preservation letter. Yes, and it's the recipient of the letter who needs to preserve documents, but it's not uncommon for then there to be some kind of teleconference with the judge saying, hey, we were willing to do this for a little while. It's
Right.
becoming onerous. And if it's an undue burden, then there may be some burden shifting, which is continue to preserve,
Right.
but the person who's asking you to preserve it is going to help foot the bill.
That does occur.
And that may occur here.
Okay.
The question that flows from that, I'm intrigued by you saying, and I appreciate it only applies to this case, doesn't any other case, that you and Mr. Harding might be able to narrow the scope of what needs to be preserved. In these boxes, they're not randomly numbered, but it's 1 million boxes. How do you go about saying, you know what, we only need box 17?
Well, we do not have the index to what's in the boxes, I don't believe. But if we define what we want, as an example, one of the things that we've been after in the case is the original absentee ballots. And the program, the plan was to get the physical ballots, scan them at high resolution, and return the physical ballots to the county. That's going to be less than 48 pallets. Now, it's a lot of ballots, okay? 147,000 approximately absentee ballots. And I believe there's envelopes still. Do they preserve do you know if they preserve the absentee ballot envelopes?
I'm sorry?
The absentee ballot envelopes with the signatures on the outside? Do you know if those are preserved?
I believe everything's been
Okay.
preserved that was stated in
You know, they're
that.
separated from the ballots. And you can't match them up once they're separated, but there is some informational value in those envelopes that may have a bearing. But my point of saying that, Your Honor, is that if we can say, okay, these are the categories that we really need, and if we get those, we can let it go. And I don't know how they keep their records, but that might permit them to say, okay, it's these 4 pallets.
Got it. Okay. And that would be a
we'll work
balancing
on that.
test as well, because you might be able to do that. And then the response would be, that would be so burdensome to do that. We just soon figure out a way to keep everything and find that middle ground.
And then, you know, there was an order entered. I'm speaking from a little bit of ignorance here, Mr. Harding will correct me if I'm wrong. There was an order entered for this to occur before the case was dismissed for lack of standing. Okay, and elaborate plans and preparations were made with an elaborate procedure to carry out the physical scanning process. Equipment, so there was a bunch of work done to line that up. I am not familiar with whether the clerk's office or the board or the county had agreed to all of that, but there was a good bit of work on this side of the V to prepare for that. Did that get shared with the county at the time? All the work that y'all did to prepare for scanning? Yeah. So it was all transparent, but I don't know whether they agreed to it then or whether they would agree to it now.
Okay. All right. Well, I think step one is I'll need to talk with Judge McAfee. If his response is we need to preserve it all for his case anyway, then you can continue your efforts to focus, but that would be to focus which boxes do we open, not what do we preserve. And then we'll need to pivot to where is a different place these boxes can go. And if the answer is someplace that there is a recurring cost that is connected with that, then we talk about burden sharing as well, and see from that. But for now, that order is in place, so nothing should be destroyed. But Ms. Moore, I appreciate you flagging this. I am mindful that there's a clock ticking and boxes are going to start showing up that need to go in the cage, and that it'll be complicated finding a home for them. All right. And if for some reason we aren't moving fast enough, please send an email to everyone saying it's happened. That truck, you hear that beeping in the background? That's that truck backing up, and it's full of the May election boxes, and they have no home.
Thank you.
We would
You're
not
welcome.
want to have homeless election records.
No.
That happens Friday.
But you know it's happening on Friday? Oh, don't call me then, so we know it's happening on Friday. All right. Well, we'll see what happens. Okay. Thank you. What do you want to do next?
If I may, I would suggest we do the motion to substitute.
Okay.
And if I could approach, it's our motion. Councilman Wacker.
Sure.
Thank you very much, Your Honor. All right, so Mr. Harding filed the motion to substitute. We adopted that motion. And the motion sets out 2 statutory grounds for adding these parties. And just to back up a little bit, as you are undoubtedly aware, the original roster of election board members has turned over, and we're proposing to replace the members who have departed with the members who have come on.
Tell me why, this is going to sound like a naive question, but sort of structurally, why do you need to do that, given that, 1, these people were sued in their individual capacity, and 2, the new slate of election board members, they had nothing to do with whatever
Yes.
necessarily. And I know if this is Smith versus the Department of Corrections, and the head of Department of Corrections switches, as long as it's in his or her official capacity, it's a matter of course that we
Yes.
swap
Yes.
the name of that respondent out. But this is neither.
Yes, that's true. And we are in, so that's a good question. It's a question that I have also wondered about. And the answer is that when this lawsuit was filed in December of 20, it was before the effective date of the constitutional amendment partially waiving sovereign immunity for the state and the counties. And that amendment has some procedural requirements, which is that you name the entity, not the individuals in their individual capacity. And if you get that wrong, you're out of court. Well, this was filed before that effective date. Earlier in this case, there was a sequence where Judge Amaro replaced the individual board members with the county, the clerk, and the board. And I wasn't there for that, but I believe the thinking was that's what we need to do under the new constitutional amendment. And then later they were dismissed on sovereign immunity grounds. So the law, this is the rationale. We can talk about whether this still makes sense, but the rationale was that under Lathrop versus Deal, which was then later followed in a case called Lowndes County versus Mayor and Council of the City of Valdosta, sovereign immunity does not bar suits for injunctive and declarative relief against state officials in their individual capacities. Now that sounds a little bit wacky, right? You're suing a government official in their individual capacity to get government compliance with an injunction. That's a little bit counterintuitive, but that was we can say that's where the ball lay under Lathrop versus Deal before the constitutional amendment. And so that's why we're in here seeking to put them in as replacements in order to get relief from a governmental entity. If
they are replaced, would the new ones be brought in their official capacity?
No, I think it would be the same as what I just read to you, that you have to bring the claim against them somewhat counterintuitively in their individual capacities. Now, in their individual capacities, they have defenses. They have the official immunity defense, which has a ministerial discretionary distinction, and there's a whole body of law.
But isn't that, the example you just gave that, so I'm Michael Heekin, and you've added me in my individual capacity, but I have official immunity as a defense, and it was a ministerial act. I didn't have any act. There's no action I took or failed to take, ministerial, discretionary, obligatory, or not. I wasn't on the elections board back then. And so I appreciate that I have official immunity, but I can't deploy that defense because I wasn't the official in question at the time. In fact, in my individual capacity back in 2020, I was a peanut farmer.
Citizen.
I don't know Mr. Heekin's background, but certainly not doing anything in connection with elections.
That's all true, Your Honor. But that's, the ball is in the rough. We have a very complex history on sovereign immunity in the state of Georgia. And this is where all of the Rococo peregrinations of the law left the plaintiffs when they're seeking this kind of relief against the government. And yes, it is, as I say, counterintuitive or maybe conceptually a little bit incoherent. But, if you look at the Sons of Confederate Veterans case, almost 14,000 words disentangling the history of standing. Okay. They refer to the statute 9-6-24. It's in the mandamus chapter. And it basically says that citizens have a right to enforce public rights against government officials. Now, that's a statute. It's not, if there's a constitutional immunity, it doesn't get past that. But that also applies historically and recognized in Sons of Confederate Veterans to claims for injunctive relief. In some of the cases they cited there's one called Head versus, I can't remember who, but the Head case one of the defendants, the individual defendants were members of, and the board of chiropractic examiners was also a defendant. That's a state body. Okay. The case of Barrow versus Raffensperger, which was 2022, was a mandamus under 9-6-24 over an election. And so was that in your court?
No, I just am familiar with the case.
Okay. You had a look of recognition. That's why I asked. And so these claims do lie against these officials in their individual capacities, because that was the only way left under the structure of immunity law prior to the amendment. Post-amendment, you can't sue them individually. You have to sue the entity.
Which is why Judge Amaro swapped them out.
Right. That's right. That's right. So continuing, so the two statutes that were cited in the motion were 9/11/21, which is substitution, and 9/11/25, which is adding parties. And 9/11/21 gets to the point that Your Honor was just making, which is that you have substitution as a matter of course for official capacity claims. And the statute does not address the little corner of the law that we're in here, where you have an individual capacity claim. And they make that point in their briefing, and that's a fair point. The statute does not address individual capacity. And that's why Mr. Harding said, it's an unusual, in the unusual circumstances of the case, in the alternative, we asked the court to exercise its discretion under 9/11/25 in order to help us deal with this oddity. And on the 9/11/25 argument, Your Honor, the elements were
9/11/25 is the substitution statute.
correct.
And that's where it's either a transfer of interest. I don't think that's what you're,
And I got them mixed up, 21 and 25
you
mixed
flip
up.
them around, but I'm following you.
Okay.
So I don't know which one you wanted to start with.
Well, let's talk about, I think what we can say about substitution is that it's true that it's presumptive for official capacity claims or transfers of interest.
What does that mean and how does that happen here?
A transfer of interest?
Yeah.
So I don't think there's any case law that tells us specifically whether this is a transfer of interest. I think there are cases that would contemplate a transfer of interest by assignment or conveyance, things of that nature.
Right.
And you could make an analogy between succeeding in office in your individual capacity and a transfer in interest, but I don't think there's a case that says that specifically,
Okay.
to be candid with you.
Right.
All right,
That's my understanding as well, that would be
Yeah.
inventing new law.
right. Well, we always like to do that when we have a problem, right? So the adding the party, the considerations for prejudice to the party coming in and delay. So on the prejudice front, a couple of things. One, there's no claim for damages here. When you come on the board, at least under Lathrop v. Deal, there's always a risk that you would be sued. But in every such case, you have an army of lawyers to represent you at no out-of-pocket cost. And they are good lawyers. They do local government law all day, every day. And they know they are very knowledgeable in the field. And I used to do it. And I took advantage of a lot of plaintiffs' lawyers who were not working on it every day. There's a lot of pitfalls for the unwary litigant. But the other point is that the case was tied up on appeal for 2 years. And so the case that they cited to the court, which is called Dean v. Hunt, I think, there was an argument that there'd been a long delay. And in fact, the case had been stayed due to a bankruptcy, and there was no prejudice. And here I would make the analogy that while it was pending on appeal, there's nothing we could do Therefore, there's no prejudice, and we're not seeking damages from them or anything out of pocket. And the burden doesn't really fall on them individually. It falls on the county or the clerk or the board, and we have the legal fiction of them being sued in their individual capacity. So I don't think there's any prejudice to them. They've got excellent lawyers. The lawyers have continuity on the case, even though the individuals do not. So there's no prejudice there. And I would offer that they got a leg up on me since I just came into the case. So why don't we name them sooner? That's out of consideration. Well, number one, when the case was filed, they weren't on the board, as we were talking about earlier. And then we had 2 years of appeal. Then it comes back, and we have the motions to recuse, and those are decided. And there was an interval between the decision on the motions to recuse and the motion to substitute. I think it's about 5 months, 5 or 6 months. But the case that they rely on says that if the only ground for denying addition of the party is the delay, that's an abuse of discretion. And to explain the 5 months or so, 5, 6 months that I did refer to, this may not carry much weight with the court, but I'll say it anyway because it's true. Mr. Harding and I have been extremely busy with the case in Judge McAfee's court.
But that just makes us feel neglected, not pitiful.
Well, I say it may not be a legal argument, but that's your excuse. That's my story, and I'm sticking to it. And it's true. You would not believe how much work I have done since August the 14th for Mr. Jeffrey Clark. So we're asking you to exercise your discretion to add the parties to resolve the we got people who've left the board. They don't need to be in the case anymore. The new people on the board do need to be in the case. And this is all, genuflecting to the legal fiction imposed on us by Lathrop versus Steele.
Okay. Thank you.
Thank you very much, Your Honor.
You're welcome. So, Mr. Kaplan,
Your Honor, did you want to ask Mr. Harding if he had anything to add? I thought you.
I do. I just want to make sure. Are you okay if I ask Mr. Harding before you start?
I sure am.
Great. Mr. Harding, anything else?
Just one quick one, Your Honor. As the court saw the Lathrop case, that was the law when we filed in December 2020. There wouldn't be any reason to keep people who no longer are on the board on there. Because if you got an injunction, for instance, against them, they have no authority to act because they're not on the board anymore.
Right.
So that's, I think, the general reason why we want to substitute them. We want the people who can actually act with authority from the board.
To do something.
Yes, sir.
Yep.
Thank
Okay. You're welcome. Whenever you're ready, Mr. Kaplan.
Your Honor, may I stay here?
You sure may.
Okay, I am ready.
I have a couple questions and then you can take it wherever you want. What I know one perspective is just rule on the actual substantive issues out there, because then it's sort of moot who is on the roster of respondents. Their identity doesn't matter if the motion to dismiss is granted. It's a fair perspective, and we're not going to be investing a whole lot of time on other substantive things before we clear that hurdle, however we clear it, granted or denied. But assume for a moment that the motion to dismiss is denied, or it's only partially granted, or however it plays out other than complete dismissal. Don't we need to figure out who would be the recipient of the direct, if the ultimate relief is granted and something needs to happen, that we've got the right people in the mix? It wouldn't be who used to be on the board, because we're not going in the Wayback Machine to say, oh, now you people who used to be on it need to do things differently. I'm wondering why there is even resistance to this, other than if I were Kathy Woolard, I wouldn't want my name on a lawsuit, and I respect that.
Understand the court's desire to make sure that the proper parties are identified. We don't take any issue with that. I think based on what hopefully I'll get a chance to talk about today, we still don't think you need to get there to decide the motion to dismiss, but we have no issue with the court determining who the proper parties are.
Okay. Anything more you want to add then about 9/11/21 versus 9/11/25, or you feel like you set it out in your brief? But I'm happy to hear if there's something more.
I'll just be brief. The motion to substitute, the first paragraph says it's pursuant to 9/11/25 C and D. This morning, it's still not clear, the petitioners filed a document conceding that 25C is inapplicable and D does not apply.
Okay.
So we want to, so those, I think they've conceded that there is no motion to substitute under 9/11/25 at issue here.
What is it that you're holding? What I've got in the docket from today is what would effectively be Mr. McDougall's adoption of Mr. Harding's motion to substitute. Is there something in there that says, in PS, in adopting it, we throw out the 9/11/25?
So
I
last
found
night
it
we
widely.
received,
Oh,
Okay, today as well.
okay. That just hasn't hit the docket.
Okay, and I'll just read, and this is what I said at the lectern, Your Honor, and I don't mean to stomp on his time, but I said.
It's not a time thing.
They contend that C is inapplicable because it doesn't involve a transfer of an interest, and that subsection D does not apply because it only covers government officials sued in their individual capacities. Those are fair points. That's what I said at the lectern.
Okay.
And that's why the alternative ground under Rule 21 was suggested.
Mr. Kaplan, I can get it in front of me, but I don't have it in paper. The original motion to substitute parties was solely under 9/11/25, or did it also have a 21 in there?
yes, the first, it did, the answer to your question is yes, it had an alternative. But the first paragraph says filed pursuant to 9/11/25 C and D. I
Okay,
just wanted to point out that they've conceded that's no longer the case.
okay,
And then they say, alternatively, they can do it under 9/11/21.
okay. So let's talk about 21. That's what I was going to ask you to do, is focus more on 21.
Okay, so this case, and part of the reason I wanted to make sure we heard from both parties, and they confirmed their understanding of why we are where we are in this case, is because when you ask them, why do you need this motion to either substitute or add, however it's styled, and the answer was in part because of the constitutional amendment that was passed. And so if you take a look at two things. 9/11/54B, which is a section under the judgment statute. When there's a judgment upon multiple claims or involving multiple parties, it's two extremely long runoff sentences, but if the court will indulge me, I'll just get through them quickly. When more than one claim for relief is presented in an action, whether as a claim, counterclaim, cross-claim, or third-party claim, or when multiple parties are involved, the court may direct the entry of a final judgment as to one or more, but fewer than all of the claims or parties, only upon an express determination that there is no just reason for delay, and upon an express direction for the entry of judgment. That's the first run-on sentence. So that's this case. Multiple parties, fewer than all were dismissed. However, there was not an express determination or two express determinations. Okay? So that brings us to sentence 2. In the absence of such determination, direction, any order or other form of decision, however designated, which adjudicates fewer than all the claims or the rights and liabilities of fewer than all the parties, shall not terminate the action as to any of the claims or parties. And the order or other form of decision is subject to revision at any time before the entry of judgment, adjudicating all the claims and the rights and liabilities of all the parties. So we're traveling under 9/11/54B. Now, today, this morning, we heard that part of this motion relates to the constitutional amendment. That's not the first time that has come up in this case. If you review the June 21st, 2021 transcript of a hearing before Judge Amaro, other counsel petitioners also said that we're doing this because of the amendment to the Georgia Constitution, another attorney who was previously involved in the case, Mr. Samuel, talks about the impact of the constitutional amendment. In January of 2024 of this year, the Georgia Supreme Court said, because appellants, and I'll give the cite in a second, because appellants relied at least partially on paragraph 5's waiver of sovereign immunity in pursuing their actions, appellants filed their actions pursuant to paragraph 5. Actions filed pursuant to paragraph 5 must name as a defendant only the state of Georgia, or the action shall be dismissed. This is Lovell v. Raffensperger from January 17th, 2024. So you pull all that together, you have a motion to substitute that would, if granted, put us in a position where there is a conflict between the case shouldn't be allowed to continue under their theory.
The substitution would result in dismissal, according to your read of Lovell versus Raffensperger.
So, and other cases, right?
Sure. It's not an outlier. I understand your point.
Right. So
why did Judge Amaro, depending on him, why did this case travel back to naming the members of the Board of Elections? I understand why it shifted to get the people out and put the agencies in. That's how we operate now with paragraph 5 or section 5 of that amendment. And if we're taking steps now to modify things, it seems like it would be under the current regime, even though this action was filed before that regime. It is now what controls. Why was it Judge Amaro who directed that the agencies be, or he dismissed them?
No, I mean, so these motions were generally by petitioners. They tried to, they filed motions to add or substitute. They filed motions to add additional parties who were, some of those motions were not granted. The tortuous road of adding and subtracting and parties, I can't speak to the wisdom of that.
Okay. But your point is, as I'm following it, I'm still not sure how 91154B ties into it, but if the relief sought here is granted, meaning simply we substitute the 4 names for the previous 4 names, we would be putting in place parties whose presence would require the dismissal of the action under the Supreme Court's application of this constitutional amendment.
Right, and let me clarify then why 91154B is relevant. The clerk and the county and the BRE were all named here, and the action was not terminated against them under 91154B. So the case violates the law of the General Assembly as interpreted by now multiple cases of the Supreme Court.
Okay.
Happy to answer any other questions.
No, I'm going to pivot back to Mr. McDougall. Tell me why the proper structure of the case shouldn't be petitioners versus name your agency.
Okay. Depends on how you interpret and apply the effective date of the amendment.
Why? Why does that matter? Because we're there now. We operate in a world. I'm not following how I get it when the Court of Appeals is dealing with a trial that happened before the change in the evidence code. They don't apply the new evidence code because it wasn't the law at the time. And so when this action was filed, it needed to be filed a certain way, but that requirement isn't the law anymore. Why wouldn't we and shouldn't we adjust the style of the case so that it conforms with the law?
Well, it should conform with the law. The question is, what does the law require? All right, so I want to give you a little bit of procedural history, then we'll come back to what the law is.
Okay.
Procedurally, an order entered by Judge Amaro on April the 21st of 2021. On January the 27th of 2021, the petitioners filed a motion to substitute parties and enter prior orders nunc pro tunc. And at that time, the petitioners said, hey, we read that amendment. We think we need to put the entities in as defendants. And
Add them or replace them?
replace them.
Replace
substitute.
them. Okay.
And in fact, that's what happened.
Yeah.
That's what this order entered April 21st. It says, during that hearing, respondents did not oppose the motion. Okay, so they consented to it. And accordingly, it is ordered that the motion to substitute parties is granted and the individuals were replaced with entities.
Okay.
Now, later, maybe they studied that amendment text a little bit more carefully, and they came back and moved to dismiss based on sovereign immunity, dismiss the entity defendants, and they were dismissed based on sovereign immunity. And in that order, he put the individuals back.
Okay. So that's how the individuals got
Right,
back.
that's how they got back. So they called it ping pong and cited Kurt Vonnegut. I confess, I did not get the Kurt Vonnegut reference, but
Okay.
they did talk about ping pong, and that I do understand. So here's what the amendment says, and this is obviously what they were struggling with there in 2021. The amendment says it shall apply to past, current, and prospective acts which occur on or after January 1, 2021. And there was argument between the parties about whether that controlled this case or not. And I think that language is opaque in the sense that it applies to past acts which occur on or after January 1. And it's a little bit of a contradiction in terms, but I think to make sense out of it, it applies to things that happen after January the 1st of 2021. And the events at issue in this case, it was the November 2020 election, so it's under the old regime, the ancien regime. So that is the answer to that. Now, so they did not oppose being added to the case. And now they're seeking attorney's fees for being added to the case.
All right. Don't stray.
I'm sorry about that. I couldn't
All right.
help it.
So you don't speak for Judge Amaro, but Mr. McDougall, why wouldn't the result of a successful motion to dismiss on sovereign immunity grounds have been the dismissal of the action rather than the dismissal of the entities and the reinsertion of the individuals?
The short answer is I don't know exactly. I believe, and Todd will correct me if I'm wrong, I believe the reasoning was that since the case related to the November 2020 election, which was before the effective date of the amendment, that the amendment did not control the arrangement of the parties or require dismissal. Is that fair?
Yes.
Okay. Mr. Kaplan, I'll need to read it, but do you agree that the constitutional amendment has this, I'm gonna call it start date, that it governs actions that occurred on or after January 2021, and this challenged activity predates that, so it wouldn't, even though you were citing to cases that say, here's how it works, they're describing something that works with a start date of January 1, 2021. And yes, we now are in 2024, I appreciate that, but this case relates to something that predates January 1, 2021.
I've read that constitutional language many times in preparation for today. I can agree with you that the acts at issue here happened before 2021. I'm not here today to parse that language, which I find extremely confusing.
Okay, well, except you are.
So we're happy to brief that in a,
Yes.
you know, we can brief that issue and any issue that the court wants in greater detail. I had planned to be here prepared to focus mostly on the motion. So the interpretation of that constitutional language.
Okay. I will let you know if I need additional briefing. Is there any part of this case that's simple? Or is all of it like this?
It's a collection of law school exam problems.
Yeah. All right, let's turn to attorney's fees. Ms. Burwell?
Yes, Your Honor. Fulton County is seeking fees in this instance under 91514, given the fact that these petitioners have taken a position in their complaint that is meritless. And if the court looks no further than the petition itself that was filed on December 23rd, 2020, and the exhibits, all of which is about 100 pages, you will notice that many of their exhibits are affidavits that were done in a federal action. And the court will recall that back after the election, there were plenty of lawsuits filed alleging fraudulent activity on behalf of Fulton County election workers, including, if you look at, again, at their exhibits, like Exhibit C and E, they have just taken affidavits that were done in the Lynn Wood case, making these same allegations that these plaintiffs have made. And as the court is aware, all of these claims of election fraud have been debunked, not only by courts, but also by, you'll note in the record that the Secretary of State provided a report on October 12th of 2021, and Judge O'Mara entered his order dismissing all on the next day, October 13th. And again, if the court looks at this response of the Georgia Secretary of State, and it was filed on the 12th, October 12th, 2021 at 3:42 p.m., again, debunks all the things that they're saying here in this action. And so as a result of the lack of merit of the complaint, and I know that the court's not going to get into the merits today, because I know that it was sent back from the Court of Appeals for you to look at the standing issue with respect to the Sons of Confederate Veterans. And then I'm assuming the court's going to look at all the other grounds that were raised in the motions to dismiss, which, as you know, Judge O'Mara stopped at the first issue and said all the others are moot. But we believe that this court goes back and looks at all those. You'll see that there was merit to all of those. And as a result of the lack of merit of the petition, Fulton County filed its brief and motion for attorney's fees. And as I stated earlier, the only fees that we're going to be attempting to get are those of Mr. Lohman, because again, Mr. Lohman is still with the office of the county attorney. So I would call Mr. Lohman as my first witness, Your Honor.
All right, before you do that, I know one of the arguments, I believe, one of the arguments that we'll hear from the petitioners as to the clerk was that the court added the clerk as a party. It wasn't the petitioners who said, we want the clerk in the mix. Was your client added by the court or by the petitioners?
It was ordered by the petitioners, Your Honor. They filed multiple motions to add, the first of which was filed on January 27th, 2021, 4:56 p.m. And in that, they say that they are seeking to add Fulton County, the Fulton County Board of Elections and Registration, and the Clerk of Superior Court of Fulton County. And that's the motion to substitute parties and to enter prior orders nunc pro tunc. And again, that's dated January 27, 2021. So these petitioners asked that the clerk, Fulton County, and the Fulton County BRE be added. And
So-
again,
So I'm misconstruing misunderstanding the step that Judge Amaro took. When he did, it's not if, when he did effectively replace the commissioners, whatever we call them on the Board of Elections, with these agencies or these entities, that was pursuant to that January 27th, 2021 motion.
Yes, and Your
Okay.
Honor can look at the order which on this motion to add, and that's dated April 21st, 2021 at 10:30 a.m. And it says on January 27th, the above style petitioners filed a motion to substitute parties. And so he was entering an order based on their request. And counsel for petitioners made the point that during the hearing, it says respondents did not oppose the motion. And he tried to argue as if that meant Fulton County hadn't opposed the motion. Fulton County wasn't there. These people weren't entered until this April 21st, 2021. So any hearing they had in March didn't include any of these respondents. So they couldn't have, so to say, you know, somehow people who weren't present and weren't aware of any of this somehow should have appeared and filed an opposition.
The March 15th hearing, 2021,
Yes.
there were no county attorney people there. It would have been private counsel for all of the respondents?
No, the council that was present, because the entity that was in, the individuals that were in at the March 15th hearing were the individual members of the VRE and Mr. Barron, I believe.
Yeah.
Yeah.
And
So the lawyer that was there on their behalf was not there on behalf of the county. She was there on behalf of the respondents at that point in time, who were Mary Carol Cooney, Ms. Nuruddin, Ms. Ruth, Mr. Johnson, Mr. Wingate, and Mr. Barron.
okay.
So they were the respondents then, not Fulton County.
No, I got that, but your point is that the county attorney who was there for those individuals shouldn't have been expected to, and it may even have been improper to say, well, I want to object to you adding other parties because I know there's an issue adding the county.
Well, the county attorney that was present doesn't have the authority to represent anybody other than who the Board of Commissioners has
Okay,
said.
that's a better way of putting it.
Yeah.
Okay.
She can represent. So she wouldn't have had the ability to speak on their behalf absent approval of representation.
Okay. All right, if you want to call Mr. Lohman.
My name is David Lohman, first name David, last name Lowman.
How long have you worked at the Fulton County Attorney's Office?
Since 2013.
And can you tell the court what areas you practice in?
Okay, when I first came on, I would have been representing the public safety clients. So that would have been the sheriff, the police, and the marshal, I think maybe animal control as well. And then in 2015 or 16, I switched over to a different set of clients, including the elections department, which is separate from the Board of Registration and Elections, which was also my client, and the Office of the Auditor and the Finance Department.
Now, prior to coming to Fulton County, did you practice?
Yes, I've been a member of the Georgia Bar since 1998.
98?
Yes,
You practiced that entire time?
yes,
And you said you've handled election cases since 2015 or 2016?
yes, ma'am.
And in handling election cases, does that include, tell the court what that includes?
Okay, so-
Litigation,
So
advice?
as the court well knows, the elections department is kind of a hot button client to have. So we not only advise them on day-to-day logistical and just regulatory and statutory compliance, but we also defend them in litigation. So we defend them in the state and superior courts, and also before the state election board and any other matters that come before the Board of Elections.
Do you also represent Fulton County in cases in which the county sued?
Yes.
In election cases?
Yes,
And how long have you been doing that?
been doing that since 2015, 16.
So were you counsel of record in the current case?
Yes, for Fulton County.
And when did your representation of Fulton County begin?
It would have begun, well, here's the situation in this case. Because Elections Department is my client, and this was, an elections case, I would have been involved tangentially from the beginning because of the type of case it was. There was an issue with service for the longest time, so there wouldn't have been an entry of appearance for a while because of the status of the case. But I would have been involved from the beginning, and then when Fulton County was added as a defendant, I would have entered an appearance on behalf of Fulton County at that time.
Okay, and did you do that?
Yes.
Let me show you. Let me give you copies. May I approach, Your Honor?
Yes, ma'am. Thank you.
Is that this?
Yeah.
Thank you.
I'd like you to ask you to look at what is identified as FC1. You see that document?
Yes.
Do you recognize that document?
Yes, I do.
Is that the affidavit that you prepared and submitted in connection with your motion for fees?
Yes, it is.
Now, did you actually draft the motion for fees for Fulton County?
I did.
And is the background material you have here on your practice of law and where you went to law school, is all of that accurate?
Yes, it is.
Okay, so you told the court you've been practicing since 1998,
Yes.
and you're a 98 graduate of Duke University School of Law,
Yes.
and you're fitted to practice in Georgia.
Yes.
And so when it comes to the information, let me ask you first about why you drafted the motion for fees based upon 915-14.
As we've already discussed here today, the claims were meritless. It was,
I'm going to object. This doesn't go to his hours or the reasonableness. He's making a legal argument as a witness.
Well, Your Honor, I wanted to give the court some information on why we had actually filed the motion, because I think that the court needs to determine whether or not do you agree that it's meritless before you would award fees. But if they concede that it's meritless, then I'm happy to go on to fees. So let me ask you about the fee issue.
yes.
Do you know what rates Fulton County currently pays outside counsel on election cases?
I believe for cases that need outside counsel because of either a conflict or the type of case it is, they are farmed out to outside counsel. And I believe the hourly rates that are charged on behalf of Fulton County range from $250 an hour to $400 an hour, depending on, I guess, the case and the seniority of the person doing the work.
Okay, so in this particular instance, when you worked on this back in 2021, how many years had you been practicing at that point in time?
That would have been 23 years.
And so I think you said that the maximum Fulton County generally pays outside counsel is $400.
Yes.
And what rate are you requesting in connection with this case?
$300 an hour.
Now, let me ask you about what is marked as FC2. Can you tell the court what this document is?
This is a listing and a chart that contains the fees that I'm asking for in this case.
Okay, can you tell the court in general how you determined the amounts? We know that the rate 300 you thought was a reasonable rate based on your experience.
Correct. And so it would have been based on the amount of time I spent on the tasks. And these tasks would have been completed by me because of the way that the case was staffed at that time there would have been a deputy county attorney, a senior county attorney, and a staff attorney. And at that time, I was a staff attorney 3, I believe. So I would have been the one doing the research, drafting the pleadings, drafting any memos or any briefs in this case. So I went back, figured out when they were done, and figured out the amount of time it would have taken through the pendency of this case. And that's what we put on the chart.
So did you actually spend at least 26 hours on this matter?
At least, yes.
Your argument for the F1, FC1 is already in the record, it was attached. So I move for the admission of FC2.
No objection, Your Honor.
FC2 is admitted.
I have nothing further.
What was the issue about disqualifying Steve Rosenberg? What was the
Okay, so-
claim as to why he should not be representing the county?
Okay, so early on in the case, in the petition, there were claims for Open Records Act violations. And at the time, Mr. Rosenberg, who was a deputy county attorney, was also the custodian of the records for the county. So there was a hearing early on in the case wherein Mr. Rosenberg testified to the open records issues. After that hearing, the judge entered an order whereby those issues were resolved. I believe he dismissed one of those claims and granted 2. So there were 3 open records claims that were resolved, that were not appealed, and that they were done. Then, because of the procedure in this case whereby the parties were substituted and Fulton County became a party, and the deputy county attorney that might have been representing Fulton County was already representing another party, Mr. Rosenberg entered an appearance on behalf of Fulton County. And when he entered his appearance on behalf of Fulton County, there was a motion made to disqualify him for being able to represent Fulton County because of the testimony he had given previously.
Okay, thank you. Mr. McDougall.
Thank you very much, Your Honor. Good afternoon, Mr. Lohman.
Afternoon.
You and I met the first time this afternoon, right?
Yes,
Very nice to meet you. Is it fair to say, Mr. Lohman, that you do not keep contemporaneous time records as you
That's
work?
that's fair.
Okay, and so these time entries are estimates that you made looking back at the work that you did?
There would have been estimates made at the time that I would have done the motion, yes.
Okay, and the best you could estimate?
Correct.
Okay. Now, you said a minute ago that the Judge Amaro granted relief on 2 of the Open Records Act claims, is that right?
I believe so, yes.
And that would be counts 9 and 10?
I believe so.
Okay. And you recollect that was his order dated April the 20th of 2021?
I don't recall that off the top of my head, no.
All right. Well, I've got a copy. If let me show it to you. No, I don't have an extra copy for you. But that's full. Yeah. And I'm afraid I don't have one for the court. And I just want to refresh the witness's recollection if I could.
No, I've got it right here. This is the April 20th order.
Correct.
Okay.
Okay,
All right. So in that order, the court granted, you said denied on 1 Open Records Act claim, but granted relief on the Open Records Act claims in counts 9 and 10, correct?
yes.
All right. And the defendants in the caption in that order?
Fulton County Board of Registration and Elections, and Fulton County Clerk of Superior and Magistrate Courts.
All right, sir. And do you recollect that Judge Amaro entered a temporary injunction directing the clerk, or directing the respondents, individual board members, and all others acting in concert with them to preserve the election records?
Yes,
Is it correct that when that order was entered, May I approach, Your Honor?
Yes.
In January of 2021, you were not working on this case?
I wouldn't have had entered an entry of appearance, no.
Well, my question was, were you working on the case?
I probably was working on it behind the scenes to figure out what was going on because as I said, the Board of Registration and Elections and the Elections Department of Fulton County are both my clients.
All right, sir. And so that means that when the board members are sued, as they were in the original filing in this case, you are involved in handling that case in some capacity?
I would be involved as far as finding out what the case was about, seeing if anybody had been served, finding out what court it was pending in, that kind of thing. But no, I wouldn't have been involved in representing anybody until they asked for my representation.
Do you have cases in which you represent individual members of the election board?
I believe I have in the past, yes.
And from one case to the next, how is it determined whether you represent individual board members or the Board of Elections?
Okay. It depends on what kind of case it is. It depends on how many entities, departments, or individual members are being sued. And it depends on what the Board of Commissioners decides, because they have to make the decision on whether to provide representation for any of these entities. And if they do provide representation, they decide on who does it. So it depends.
So the Board of Commissioners is deciding case assignments inside the county attorney's office?
The Board of Registration and Elections is deciding whether the county attorney's office is going to provide representation.
Okay, I had my boards confused. I thought you were talking about the Board of Commissioners, so help me out. It's the Board of Registration and Elections decides whether to request representation?
They request it.
Okay, and then what happens?
And the Board of Commissioners has to decide what the representation will be. See, although the Board of Registration and Elections is separate from the Board of Commissioners, because the county is tasked with providing elections for the county. So the Board of Commissioners does that. So although the Board of Registration and Elections is separate, any monetary decision, any budget, anything that has to be decided by the Board of Commissioners because they represent the taxpayers.
And so it's because of their authority over expenditures that the Board of Commissioners is involved in making that decision?
That'd be correct.
And is there an internal accounting charge for your time when you're representing the election board or the members of the election board?
No.
I'm confused. Does it result in any additional expenditure that would be a concern of the Board of Commissioners?
My time that might be taken away from other clients.
But there's no financial transaction there.
I don't get money in my hand and they don't. No, it doesn't work that way.
Okay. And so as far as you know, there's no charge to the budget of the election board for your time?
That is not true. The election board has to have their budget approved by the Board of Commissioners.
Right.
And so when they make that approval, all of that will be taken into consideration.
All right, sir. Now, in some cases, you represent the county proper, correct?
That's correct.
And in other cases, do you also represent the clerk?
I don't represent the clerk personally, no.
You've never represented the clerk?
I don't want to say never because there are several different types of cases that might come through our office. So, but it would be very rare and not a common thing that I would represent the clerk.
All right. You have subject matters and departments that you specialize in, and other lawyers have departments and subject matters they specialize in?
Yes.
Okay. And right now you're on the election beat.
Part of my clients are Department of Elections.
All right. Now, when this order from April the 21st of 2021, may I approach?
You have continuing authority to approach the witness.
Many thanks.
Okay.
Okay, so when that order was entered, is it fair to say you were not working on this case?
It was fair to say that I had not entered an appearance because
Okay.
when Fulton County was added as a party, that would have been the first time that I would have been entering an appearance in the case.
Before that, do you recollect who was handling the case within your office?
I believe Cheryl Ringer would have been handling the case in my office, but I also believe that there were other attorneys involved outside of the office.
Did you confer with them about the case before you came into it to represent the entities?
Yes.
So how did you learn that the entities had been added to the case?
I would have been made aware of this order when it came in. It's an e-file order, so it would have come across my desk probably some kind of way.
To your recollection, was the motion to add the entity, to substitute the entity parties discussed with you before the appearance on March the 15th, I believe it was, where the attorney for the individual board members did not object to the substitution?
Can you repeat that question?
Yeah, I sure can. That was a bad question. I apologize. This order recites that on March 15th, there was a hearing on the motion to substitute the entities in for the individuals. Did you confer with the lawyer handling the case about that motion before that hearing?
No.
So it was a surprise to you to learn that Judge Amaro had ordered substitution?
I won't say it was a surprise. I mean, I learned of it when I learned of it, but I don't think I conferred about a motion that I wasn't involved in the motions hearing.
No instructions were given to the lawyer handling the case to object to the substitution?
Not that I'm aware of. I wouldn't have done it.
All right. Ms. Ringer didn't do that, do you know?
Not to my knowledge, no.
You were sitting in here, which is fine for some information I received from Ms. Burwell, that the way it works with your office is that if you have been named as the attorney of record for a Fulton County entity of some sort, and that's been authorized by the Board of Commissioners.
2 boxes of canned spaghetti, buy one, get one free. 2 boxes of Fruit Loops, buy one, get one free. 2 packs of Reese's Chips Ahoy, buy one, get one free. 2 bottles.
Well, that's awkward. That was someone from my staff who got off mute and we got to hear whatever they were watching in the background. We'll have words with that staff member later.
It could have been a lot worse, Your Honor.
Exactly. So you're representing animal control. You've been designated to do that. That's what the county has authorized. And you're at a hearing where the judge says, by golly, I'm going to make life difficult for Arthur Ferdinand and the tax office in this case as well. You can't say, wait a minute, Judge, let me speak up, because that's the county as well. And you know, if you check my lapel, it actually says Fulton County Attorney. And so I'm gonna say something about that. That would be outside your scope of authority.
That's correct, Your Honor.
Okay. I just want to make sure that's how I understood it. And so a lawyer who would have been in a hearing where Judge Amaro was starting to talk about adding other county entities, who is a Fulton County attorney, ought not to be saying, I got to give you the view of those entities.
That's correct.
Okay.
All right, sir, going back to the time entries, we got the
Okay.
first one is reviewed order granting motion to substitute party. So that would have been after the order entered on the 21st, substituting parties, right?
Correct.
And is it the case that you had no time attributable to this case before that?
I wouldn't say I wouldn't have no time, but it wouldn't have been proper for me to build time for you because I wasn't involved in the case on an official basis. I hadn't filed an appearance.
You might have been a team player helping people out, but it's not billable in the same way that if we were at a law firm and I'm walking down the hallway working on the McGillicuddy matter, I'm like, hey, Loman, you know something about trust in the states. How does that work? And you give me 10 minutes of your time. I got to stick it to the McGillicuddys.
Never make it in private practice.
That's why I'm here. That's why I'm here. That's 1/10 of an hour don't work for me.
6-minute increment.
Yeah.
Okay, so May 21st. All right, sir. I'd like to show you the order dated May the 21st of 2021.
Yes,
You recollect that order?
I do.
And that's an order from Judge Amaro to unseal the election records.
Yes.
And so that was a grant of at least some of the relief that the petitioners were seeking.
Yes.
All right, sir. That's all the questions I have, Your Honor. Let me see if I can get back what I handed.
No,
out
you
to
can't have it back.
Your Honor, we do not object to Mr. Lohman's hourly rate or his hours.
Got it. Thank you.
We object to the liability.
Right. But the hours are reasonable and the rate is reasonable.
They are.
Okay. Stay where you are for 1 second because Ms. Burwell may have some redirect. I'm just fascinated by this order as I work through the docket. So Judge Amaro said that the records, the absentee ballots could be scanned and inspected. Things got stayed and that's why it never happened. I mean, these are the boxes, making the number up, but these are the 48 boxes that you'd actually want and you could scan them, but that's clearly never happened because they're all still shrink wrapped, filling up that poor cage.
I think that order touched off a fire drill at the Secretary of State's office, and they showed up and said, wait just a minute, these people don't have standing. And they persuaded Judge Amaro to hold off, and then they had a hearing on the standing issue and he dismissed. Isn't that right?
Yeah, well, it was also stayed because there were motions to dismiss filed, which under 9/11/12 kicked off the 90-day stay.
Right. And then there was an appeal. And so if people had just gone about their business and not, I understand why things were filed. It's not a critique there. But if there had been no steps to dismiss or this or that, then those boxes could have been opened and things scanned and the cage could be emptied, at least vis-a-vis this litigation.
Yes, my recollection is his order said we were going to meet maybe 7 or 10 days later.
Yes.
And before that date that we were going to meet, the motions to dismiss were filed.
Got it. Okay. Yeah, it was May 28th of 3 years ago that you were going to meet to talk about how to do that. Huh. Yeah, it was going to be a field trip. You were going to appear where the ballots were stored.
Yeah.
I had my bag lunch ready.
Yeah.
I had Mr. Harding's client over here, Mr. Favorito, organized a big team and elaborate set of procedures with equipment and everything. I mean, it was
Okay.
mapped out and planned out. But, you know, the government reacted the way they reacted, and here we are.
Here we are. All right. Ms. Burwell, did you have any follow-up for Mr. Lohman?
I did not, Your Honor. I only wanted one housekeeping. I would like to move for the addition of FC1, just so it's in the record.
Okay. I think you said it's already in the record, but we'll be extra clear and we'll make it in today's record.
Thanks.
Any objection, Mr. McDougall, to FC1, which is Mr. Lohman's affidavit?
No, I mean, if I was going to be picky, yes, but I'm not going to object. Mr.
Okay.
Lohman has testified to what's in the affidavit, and it's fine. It's cumulative. It doesn't bother us at all.
All right, it's in. FC1 and FC2 are admitted and you, sir, may step down.
Thank you.
I have nothing further, Your Honor.
Okay,
Fulton County's motion, thank you.
got it. Mr. McDougall, anything you want to add in terms of liability?
Oh, yeah, absolutely.
Okay,
Absolutely.
other than that you object to it.
Yeah. So the, the orders. So one of the prerequisites to liability under 915-14 is that the action be frivolous and that no reasonable lawyer could believe that they would get relief in the case. And the fact of the matter is relief was granted by Judge Amaro in multiple instances. One, the temporary injunction order. Two.
The temporary injunction meaning don't destroy the records?
Correct.
Okay.
So that was really, I mean, our side asked for that, it was granted. Secondly, the claim of frivolity is that you brought in the county and you're not allowed to bring in the county because of sovereign immunity. But the fact of the matter is, the Judge Amaro is the one that ordered the county into the case. So that shelters us from any liability for them being in the case. Now, he subsequently dismissed them. That is true. But as far as bringing them into the case, there was a motion, there was a hearing, somebody from the county attorney's office didn't object, and now we've got this shell game about who they represent and don't represent in the same law firm.
Well, but so twice you said, the judge ordered it, and I think I misunderstood it both times. It's
Okay.
not that Judge Amaro sua sponte said add the county. He granted your motion
Correct.
by entering an order.
Right.
But if it was frivolous to add them because there were no claims against them, then his order doesn't insulate you from any liability. You asked for something and you got it, but if it was frivolous to ask for it, then it's frivolous to get it, and the county got dragged in. I'm not saying that's my view on it, but the county, yes, they were added because he ordered it, but he ordered it because you asked for it, and they weren't given an opportunity. I'm not blaming anyone for this, but they weren't given an opportunity to object. And as soon as they did and said, we want out, then they were out. But it cost them money to be dragged in and then get out.
So,
Yes?
when I cannot accept the framing, and here's why. The premise of liability is that no court would accept it. The court accepted it. That's the end of the inquiry. The court ordered them into the case. Now, the court might be wrong, okay? But that the court ordered it. That shelters the request to put them in the case for purposes of 9-15-14.
Is the court obligated to make an assessment as to whether it is reasonable or non-frivolous to add someone to the case when you file a motion and the court ends up granting it? That's putting an interesting burden that I'm not aware exists for the courts.
If there's a case that says you can be held liable under 9-15-14 for bringing a motion that you win, I've never read that case. Never heard of that. And the idea that there is a complete separation of identity between counsel for the board members and counsel for the entities when they're all in the same office, that just doesn't even pass the laugh test. It's imputed knowledge to the entire office. Think about how conflicts analysis works for imputed conflicts. They're assumed to know. And the testimony was they did confer. Now, it might have been just poked the head in the office, but that's enough. That's enough. Now, thirdly, the court granted relief on 2 counts of the Open Records Act claims. So that's 3 things of relief that were granted. And the 4th is the order to unseal.
Those were all parts of the original petition to get Open Records Act relief.
Mr. Harding had to help me
The
on this.
original petition did not assert open records claims. It only named the 5 board members.
Right.
And then there was a motion to add, is my recollection, and the county was brought in, and then there was an amendment that added the open records claims against the county.
They were, at some point, they were claims in there and.
Yes, sir, but not in the original.
Okay. No, I appreciate you being careful in responding, but at one point in time, there were claims for Open Records Act.
Well, the open records claims were against the county.
Okay.
But I think that was in a subsequent amendment to the original,
Okay.
is my recollection.
And moreover, not only were they against the county, which was added as a party, but some of those claims were granted.
Correct.
Yes, sir, I think it was 9 and 10, but.
Okay.
That's right. It was counts 9 and 10. And that was That was the order entered April the 20th of 21. And the order unsealing was May the 21st. So relief was granted on multiple requests for relief. Therefore, it is not possible to say about this case that it was no reasonable lawyer could believe that any court would grant the relief that was being sought, because the court did grant relief in 4 separate instances. Now, the dismissal was on standing. And after 2 years, and the Supreme Court of Georgia ruled that the resident plaintiffs or petitioners who are resident in Fulton County did have standing under the community stakeholder doctrine. So the petitioners prevailed on those claims to that extent. Now, there were petitioners that did not reside in Fulton. They were tossed. But if you read Sons of Confederate Veterans and come away from that thinking it was crystal clear where nobody could misunderstand it beforehand, I don't see how anybody could say that. That is a prodigious work of legal scholarship. Probably cites 100 to 150 cases and tries to disentangle a very tangled up area of the law. So the claims were not frivolous, Your Honor. And there's also an argument in the briefing filed by my predecessor and by Mr. Harding that once they were dismissed, they're no longer a party and they waited too long. Over 150 days between their dismissal and the filing of the motion. Now, there's an argument that until the entire case is over, you can still file the motion. So I'll just leave that for the briefs. I'm not going to pound the table about that one, but I think that we have got a per se defense because we got relief from Judge Amaro on 4 separate issues.
Okay.
Your Honor, if I could just briefly.
Of course.
The Fulton County is not seeking fees as it relates to the open records issue. So there's been the fees we're seeking are set forth in Mr. Loman's affidavit, got nothing to do with open records. The second thing I want to point out, and this again,
I may have missed that then. I know that you didn't thankfully go line by line in FC2. And there were, well, but you say that, but I have asked him about what Mr. Rosenberg had to do with anything, and that was open record stuff.
well, that was the disqualification that came later after Mr. Rosenberg came in as counsel for Fulton County.
Okay.
So Mr. Rosenberg first was in as the open records custodian and testified,
Mhm.
and subsequently, and if the court will look at the order of April 20th, is the order where the court says, yeah, there was a problem with open records. It wasn't until the next day, April 21st, that he actually added Fulton County. So there's that, yeah, there was an issue with open records, but we're not claiming any of that. And Mr. Loman's time doesn't include that because all of that predated his entries of time.
So then crystallize for me as best you can. I don't think there's a lot of crystallization in this case. What the frivolous claim is or claims are that supports the 91514, because it's clearly not the ORA claims brought against your client.
Right.
Because some of those were successful, but you're helping me understand that wasn't Mr. Loman's work. He didn't spend time defending against the Open Records Act complaints.
Right. And so this complaint says election fraud by Fulton County election workers, meritless. So that's what we're saying is meritless. All of this, you've attached, there's 100 pages, you've attached these affidavits from people who gave them, or affidavits from another case. Again, in the Linwood case, that all that has been debunked. You have again, the report from the Secretary of State saying, again, all these claims that they want to raise, that the 2020 election wasn't fair and that there was fraud with respect to tallying the votes, all that's false. All that's meritless. And here we are in 2024, still going on the same thing. How many courts have said the Secretary of State and the GBI investigating.
Okay.
Your Honor, may I respond to that?
Nope. I just needed, I don't mean to say no in the sense of, but I'm not feeling like I'm confused by where we are now.
I just wanted 2 minutes to this contention that the claim was frivolous with respect to irregularities in the election.
So then I definitely do not need to hear from you on that topic.
All right.
I appreciate there is a heartfelt belief in both directions. I wouldn't invoke Lynn Wood if I were you. That didn't end well for him. But
there are affidavits in the record in this case that support the allegations. Okay, that's testimony from witnesses. And I can put this guy on the stand and he can talk for 2 hours about what he has discovered about this election that'll turn your hair gray.
Well, I don't want my hair to turn any more gray than it is. So thanks for keeping it to less than 2 minutes. All right.
Your Honor, may I be heard very briefly? There's a reference to what the law is in Sons of Confederate Veterans that I think was a misrepresentation of the law.
Okay.
Okay, and this happened as well in this document that it seems like unfortunately you might not have, that was filed this morning.
I don't have it. I will get it. It
Right.
just hadn't hit the docket.
So what they say
Think it's in now?
in this document is similar to what we just heard this morning. The case was previously dismissed for standing. As the court well knows, that dismissal was reversed by the Supreme Court. That's not what happened in Sons of Confederate Veterans. They said this in this brief. They said it this morning. That's not accurate. I just want the record to reflect that.
Okay. Thank you. Let's turn to our last topic, which is attorney's fees concerning the clerk. Ms. Moore, you're back on.
Yes, thanks.
Don't sound so excited.
I'm wondering if opposing counsel is going to follow suit, and they did not have an issue with Mr. Lohman's rate and time, and if they don't have an issue with Ms. Baideswaran's rate and time, or Ms. Martinez and Ms. Burwell, that may save us some time, and we can just discuss.
One sec, okay?
Sure. Yeah, let him check, but I appreciate you flagging that. If the issue isn't hours and rates, then let's focus on merits, since it's 3:45.
Right, and the rate, what was her rate?
Well, we got three people, so let's get on the record. What is it that the county is contending are reasonable rates for the three? I have Ms. Burwell is the senior at 400, Ms. Martinez close behind at 350, and then the third attorney at 275.
Those rates are reasonable, Your Honor.
Okay, are those the rates you're sticking with?
Yes, Your Honor.
Okay, and then it's a math problem. It's the number of hours worked times those rates. It looks like the third lawyer spent the most amount of time on the case, which is usually what happens. The junior associate does all the work. Then Ms. Burwell comes in and claims victory.
I do all of it.
Any objection, Mr. McDougall, to rates or hours?
This is for the clerk.
Correct. 3 lawyers.
If the total of the 3 is 9,575, is that right?
That's the figure I have.
Yeah, I don't think I'm gonna be able to come up with an objection to the hours, Your Honor.
Okay, then you've made your case, Ms. Moore, as to reasonableness of rates and accuracy of hours. Why don't you tell me how this is different, or maybe it's the same? Ms. Burwell has articulated some reasons why a 9-15-14 motion is properly brought here.
Sure, okay, so the clerk's position is that the award of attorney's fees is appropriate under 9-15-14 A and B, similar to the county. Our position is that, or the conduct that we are complaining about, that the clerk is complaining about, is the fact that she was added as a party to this complaint that had absolutely nothing to do with her. So there was a total complete absence of any justiciable issue of law or fact. And clearly also, if that is met, then there was a lack of substantial justification for the action against the clerk. And I think that it's pretty obvious that the clerk doesn't have anything to do with the 2020 election. She's not an elections official. She doesn't work at the polls. She does not count ballots.
But doesn't she keep the ballots and didn't Judge, I'm just predicting what we're gonna hear in a moment. And relief was granted because Judge Amaro, we have to line up the timing. If Judge Amaro entered that order saying preserve all the electoral materials before the clerk was added,
And
then.
that's what happened.
Okay.
So the order entering or directing everybody to preserve the records, that was January 7th, 2021. And then after that, on January 27th, 2021, is when the petitioners filed their motion seeking to add the clerk or substitute the clerk for those individual Board of Registration Elections members. And the clerk was finally later added in the court's April 21st, 2021 order. So petitioners had already received their temporary injunction related to the records. The clerk has never taken a position that she wasn't going to follow that injunction or that it didn't apply to her. The clerk never was at all times a neutral party and made that very clear at the hearings that she did appear at, even before she was a party, simply saying to the court and petitioners that, you know, whatever the court directs with respect to these records, I will do. I'm not here to argue whether they should or should not be unsealed, just here to state that at that particular time, they were sealed and she couldn't comply unless, you know, the court directed her to do so. So there was never a reason or a legitimate basis to bring her in as a respondent with these litany of claims that appeared to be lodged against her. And as a result of that, then counsel had to file motions to dismiss, attend the hearing as is stated in the affidavits in order to secure the clerk's dismissal, which was warranted based on sovereign immunity, based on the fact that she doesn't take any part in elections. And so their underlying claims certainly have no merit against her. And for that reason, the clerk believes that the award of attorney's fees pursuant to 91514A or B, both, is supported.
What is your response to the possible argument we will hear that if anyone should be assessed the attorney's fees, maybe it's Judge Amaro, because he entered an order that said the clerk should be added, and because he entered that order, that must have been a non-frivolous idea to add the clerk to the case.
My response is that assumes facts and arguments that are not anywhere in this record, and the judge issued that order at their request, at the request of petitioners to add these parties. It doesn't appear that Judge Amaro considered whether their addition was futile or not, and the clerk didn't have an opportunity to address whether her addition would be futile or not.
Let me press you on.
Have a responsibility to know that.
Okay, but let me press you on that part then. I don't know that I'm swept away by the notion that because an order was entered, there can be no liability. I don't know that the judge has this anti-frivolity gatekeeping role. But I am curious to hear you about the notion that a motion was filed in a case that has a county attorney on it that says, Judge, you should add 3 county entities. And I don't mean to put you on the spot. It may be that you have to bring in the county attorney to answer this, but how is there not a reporting mechanism within the county attorney's office to say, this has just been filed in a very high profile case. The petitioners are seeking to add 3 county entities. That's going to mean 3 different teams of lawyers, because you can't have, I've learned, the same lawyer representing these different entities. They're each entitled to their own lawyer. So why would there not be an opportunity for there to be a special appearance? I think it's happened in a case I have, where a county entity specially appears, represented by one of your colleagues, saying, well, we haven't been added yet, but there's this effort to add us, and we think we'd be prejudiced, it's inappropriate, it's untimely, all the arguments you might want to make to keep the clerk, all the arguments you just made. Why are you dragging the clerk in? She didn't have anything to do with anything. And there's this temporary order, this injunction saying preserve things. The only thing the clerk has to do in relation to this is preserve the ballots. And she's doing that because you ordered us to. So there's no point in adding the clerk. Couldn't that argument have been made in advance through a special appearance, because the county attorney's office was on notice that the petitioners were going to try to add these parties because the county attorney was already on the case?
Well, I can't exactly speak to what happened then and who spoke to whom about what. But the clerk had representation at that hearing that petitioners are talking about, even though the clerk wasn't a party yet.
At which hearing?
At the hearing where petitioners said that the motion to substitute parties was not opposed. And the transcript to that hearing reflects that Ms. Vaidiswaran told Judge Amaro that when it was brought up, that this was the first time she'd seen the motion, and she was only hearing about it just then on the spot, and that the only reason that they were aware of that, the date of that hearing is March 15th, 2021. Attorney Vaidiswaran was there because the clerk had responded to petitioners' motion to compel production of these records, which were still at the time sealed. And so, I mean, I don't want to put words in Ms. Vaidiswaran's mouth, but based on this, it appears to me that she informed the court that she was not aware. Counsel for the clerk was present, stated, I am not aware of anything about this motion. And so it appears that there was no formal opposition because she was unaware. It's not to say that Attorney Vaidiswaran consented to the clerk's addition. In fact, it's surprising to me that the court would add the clerk in light of this information, being informed that they were not on notice of the fact that petitioners were seeking to add the clerk. So.
Okay. All right. Mr. McDougal?
If Your Honor, if I may, I'm going to pass the baton to
Oh, at the 11th hour.
maybe he'll do a little better than me.
I don't know about that, but I just point out 2 things, Your Honor. When you look at the motions for attorney's fees that were filed, they both in the signature block say Office of the County Attorney, both motions, the one for the clerk and for the county. In addition, there was a representation, at least at the hearing, that the clerk will follow whatever order the court gives. Arguably, I think that's a statutory requirement. That it was a Fulton County case. It was being heard in Henry. I think that was more for the ease of Judge Amaro, which I understand. And then there's this order that adds the clerk, and it binds the old temporary order from January. It re-enters it non-protunct against the clerk. So there's relief there. The temporary injunction relief was granted against the clerk. Initially, the clerk wasn't a party. It was just a notice to inspect or produce, I think under 9/11/35 that was filed. And then at a later time, there was a discussion, I believe it was an open court, and I think the judge initiated it, like that the clerk need to be a party because they're the custodian of the items. At some point, apparently there was a motion filed. So not only was the temporary injunction, non-protunct, granted against the clerk, there was also an order to unseal May 21 of 2021, that was granted. And the clerk was a party to that, and they argued against it. So there was relief that was granted. And none of the claims about election issues were those aren't brought against the county and the clerk. She's only being brought in on temporary injunction because she had custody of the records. So we think there's been relief that's been granted that would show that it wasn't frivolous, that we had prevailed at least on the claim of temporary injunction at the time.
But the relief you're describing sounds like it was basically Judge Amaro saying, I've got my January 7th order, cut, paste, and restating it. Did it create any new obligation for the clerk or bestow any new benefit upon the petitioners that the judge said, by the way, what I said on January 7th, 2021, I still mean it?
I don't think it put any additional obligations on the clerk, but I do think it made it apparent that she's a party and she's bound. There's no question at that point.
Okay.
As the court knows, usually you have to have a party to bind them to a court order. Normal.
Can I have a brief response?
You sure can.
I just wanted to point out that petitioner said the clerk argued against the motion to unseal the records, and I don't believe that's accurate. The clerk's position has always been that if the court sees fit to unseal the records, that it's really none of her business. She will just do as she's told. And I believe it was maybe the Secretary of State who took a position that the record should remain confidential. But again, not the clerk. And to your point, they already had the relief that they were seeking as it relates to the temporary injunction before the clerk was added as a party. So again, it doesn't appear that there was any reason to bring her in as a party just to get access to these records, which they could have gotten. As they said, they filed initially. She wasn't a party. It didn't stop them from filing the notice to inspect and all of that. So it's unclear why the clerk was ever added, and quite frankly, there was no justification for adding her.
The transcript that you referenced, is that in the docket or that's just something that you have? Sometimes transcripts are put in the docket, sometimes they're not.
It was attached to something they filed, right?
Yeah.
I believe it is in the docket because I believe it was an exhibit to one of petitioner's filings, but I can't tell you.
Needle and haystack.
Yeah, I have it here. It looks like it was filed on November 12th at 4:31 PM. It's called
Of what
Notice
year?
of Filing of 2021, sorry. It's called Petitioners Caroline Jeffords and Robin Sotier's Notice of Filing Hearing Transcripts.
November 12th.
November
I'm
12th,
looking.
2021.
And the page, Your Honor, that I was reading from where.
Hold on, let me get it up, make sure we're talking about 515 pages. So they
You found
attached a bunch of transcripts. So which hearing what's the date of the hearing?
It's Monday, March 15th, 2021.
This is the hearing on the motion for substitution of parties, motion, okay. So that's number 2. All right.
And I was reading from page 10, line 5.
This is a good docket entry. It's all sorts of transcripts. Okay, thank you. I think we have covered what I set out for us to cover. Let me work my way down the line. Mr. McDougall, were there other things you were hoping we would address? We talked about substitute parties, 2 attorneys' fees motions, and preserving the evidence.
Right, I think we've covered everything that was in the notice of hearing. And we suggested in the document that it hasn't quite reached your docket yet. that if the court wants to hear argument on what's left of the motions to dismiss or the remanded issue of standing in the first instance, that set that for hearing at a later time,
Right.
after I get back from the beach. Please.
Sure. Right, I need to synthesize sort of what remains and what was handed back to us, and then decide whether we need to spend some time together on that, or if I have enough.
It is a challenge to get one's arms around the case. I will,
Yeah. Okay.
thank you very much, Your Honor.
You're very welcome.
You got anything else?
Well, I was going to ask, so Mr. Harding, anything else?
Well, just a housekeeping question. If we decide that we want to roll along together later, how do you want us to handle that? Just let you know or file maybe a motion to set aside the severance order?
I think it would be the latter. We need to get something in the docket so it's clear for the archaeologists who are going to mine the docket that there was a severance and then a rejoinder. And I'd certainly I don't know who's going to be on the other side. Probably Mr. Kaplan will be the one we keep in the loop, because that's nothing to do with attorney's fees, and make sure that there is no objection from whomever the respondents might be
I'm
in the
wondering if
case.
the verb would be consolidate. Once you sever, do you consolidate?
You guys will work on that, because you'll be filing the motion that says let's reunite the parties,
We will cite Peaches and Herb.
there you go, the petitioners. So I'm going to look to you all to have that conference you need to have, and then I think it would be great. It simplifies things, but it needs to make sense, obviously, for you. And I'm going to confer with Judge McAfee about his understanding of where he is with preserving documents. And then we need to get serious about what we're going to do with all those pallets, because it sounds like the clerk's need is pretty strong for that space. Okay. Mr. Kaplan,
Nothing further at this time, Your Honor. Thank you.
you're ready for a ruling on the motion to dismiss?
Indeed, I am.
All right. Well, I know how to find you and the two lawyers for the petitioners if we need to have a conversation about it. All right. Thank you so much. Thank you, Ms. Burwell and Ms. Moore as well for being here.
Thank you very much.
Thank you, Your Honor.
May we be released, Your Honor?
Yes.
Thank you.
Ms. Burwell. Very nice meeting you. Captain? Good meeting you.
Yeah, this is probably left from earlier.
I'll be able to leave.
We are going to share. We talked about it briefly before.
Oh, yeah. Yeah. Send it.
Not yet.
Okay, good morning. Okay.
Yeah.
Okay.